Well, thank you, everybody who's joining us. We really appreciate it. I'm here today with attorney Craig Reynolds, and we are going to talk about probate court and how that affects you with selling your home and what's involved. And Craig has been a real estate attorney for many, many years. So I'm going to have Craig introduce himself and tell us a little bit about yourself in your office, Craig.
Well, thanks, Joanne. So Craig Reynolds, residential real estate is by far the largest portion of what we do with our practice. We do dabble around the edges a little bit in probate matters and as estate planning, but residential real estate primarily. I've got two attorneys with me, David Appleyard and Justin Bailey. Our main office is over in Lancaster. We have a second office, a staffed office up in Fitchburg on South Street, and then also a satellite office, unstaffed, but we have office space there, and we meet with clients frequently over in Westford. So kind of residential real estate all everywhere along the Route 2 corridor.
Yeah.
And we've been doing this for a long time, even longer than I know you've been in business for a while, Joanne, but we've been in business even
Even
longer.
longer. Yeah. I got almost 40 years. So
Yeah.
knocking on the door. I can't believe I've been doing it this long.
Yeah.
So,
Yeah, and when at the end of the day, that experience matters because basically we think we've seen it all. So whatever
yeah,
situation comes along, we've seen that before. We've got creative solutions to whatever the issue might be.
yeah. No, experience definitely helps. So let's jump right in. But like one of the things that I have a lot of people ask me, well, what's the difference? What's a POA or power of attorney? And what's involved with getting a power of attorney and what's that used for?
Sure. So power of attorney, usually, so when someone puts together an estate plan, one, the key documents that they're putting together are a will, which is controlling their, who gets their assets should they pass away, usually a healthcare proxy for medical issues and whatnot, and then a durable power of attorney. So a durable power of attorney is intended, primarily intended for situations where the person is themselves incapacitated. So medical issues or later life, competency issues and whatnot. So having a power of attorney in place, usually a family member, you've given them authority to act on your behalf, so that when it comes to selling, so we're usually dealing with elderly folk, where they're at the point in their life where for whatever reason they're not physically capable, mentally capable of handling their own affairs. So their power of attorney then steps up and can sign all legal documents on their behalf. It's critical that it be a durable power of attorney because a normal power of attorney is basically rescinded if, well, let me back up. So powers of attorney are not permanent. Once you appoint someone as your power of attorney, you can rescind that. You can change your mind, appoint somebody else. You can take that power away from them. So a regular power of attorney is automatically rescinded by incompetency, since since the person is now incompetent, can't change their mind, can't do anything, just automatically rescinded. But a durable power of attorney, specifically recognized under state law as such, is intended to carry forward after incompetency or otherwise. So 99% of the powers of attorney you'll see will be durable, but it's critical that the power of attorney have that specific clause in there so that it does survive the person's becoming incompetent.
Yeah, I think a lot of people don't realize how important it is just to have a power of attorney. I mean, my mom recently passed, and there was a lot of things that she was not able to sign. I mean, she couldn't even sign her name. So it's
Right.
really important, and I think that's really the first step to start if you're going to sell a family member's property, being able to have a power of attorney to at least start signing documents on
Yep.
behalf of the elderly or incompetent person. What is the difference between like the appointment for probate court? So they're two different things. The power of attorney, you can, have an agreement drafted and you can represent this person, or you can go to court and be appointed by the court as a guardian ad litem, if I said that right.
Yep. Yep. So if we're in a situation where we have someone who is incompetent, they own the property, but they can't sign documents for whatever the reason, and if they did not have the foresight to have a durable power of attorney in place, to have a family member who can step up for them, then you do need to go to probate court to get someone appointed to act on their behalf. It's variously the terminology being a guardian or a conservator, just depending on. So the roles between those two roles are very similar to each other, but just distinctly different powers. So just depending on the situation, which route you go there. A guardian ad litem is a specific type of guardian, and it isn't really the type of guardian that you'd be seeing in the situation that you're referring to here. But obviously it's much more time consuming and costly to go through the probate court process to get somebody appointed as guardian or a conservator, so that they can now be authorized by the probate court to sell the assets of the owner of the property. So much preferable if they had the foresight to have a power of attorney.
Yes.
So I mean, obviously everyone should have a simple estate plan of some sort in place, and the power of attorney is just one of the core documents that they will always have in that situation.
And it's just really great to have. When is probate required though, when you're selling a house? So like, your elderly parents have a property, they're going to end up going into a assisted living facility or something, and you're going to have to sell their property. How soon do you have to do that? How long, that kind of stuff? Like, when is it?
So probate, so the probate court gets involved, as we were just discussing a moment ago, if we have to get a conservator or something like that. But if that's not the case, so we typically talk about probate court in terms of processing a deceased person's, a dead person's estate.
When someone's passed.
We've got a situation where elderly mom and dad are going into assisted living. We're not really going to have a probate matter there, unless we need to get a conservator or slash guardian appointed for them. So the probate court, as far as probating the estate, only is only triggered when we've got someone who's passed away. And it is not necessarily the case. In fact, there are frequent instances where one of the owners has passed away where there's no need to go through probate at all. So explaining if our question here is, when do we need that probate? So basically, whenever someone dies, they've got assets that are in their name. Sometimes the ownership, the deed to the property, the way that property is owned by the seller and other owners, sometimes the deed will answer the question for us as to who's entitled to inherit their share of the property. So for example, if you've got husband and wife owning a property, and on the deed to the property it specifically says that they're holding title as tenants by the entirety. So magic words, if you will, but key terminology under state law, specifically for a married couple, tenants by the entirety, that wording being on the deed means that the survivor of them automatically inherits the property. So if we've got husband and wife, they own the property as tenants by the entirety, one of them has passed away, the deed answers the question. So if the husband passes away, the deed answers the question, who inherits the husband's share? Just automatically the wife does, because they own property as tenants by the entirety. So all we have to do in that situation, in order for the wife to then to be able to sell the property, is to record a death certificate at the registry of deeds to document that the husband in fact has passed away. End of conversation. Similarly, if you've got two or more people owning property as joint tenants, so again, the deed to the property has indicated that the whole title is joint tenants. Key feature to the joint tenancy is survivorship rights. So very similar to tenants by the entirety. Tenants by the entirety is a specific form for married couple. There's a few other really deep in the weeds differences between tenants by the entirety and joint tenants, for practical purposes, for realtor purposes, no difference at all. So if you've got 2 people, 3 people, 4 people owning as joint tenants, and one of them has died, again, all we have to do to handle their share of the estate is to record a death certificate, and the survivors of that group continue to own the property. If you've got property in a trust, and someone dies, again, the trust is going to answer the question for us as to who's entitled to the property. So when you've got property in trust, the deed is going to name who the trustee is. That's the person who's handling the affairs of the trust, but they're doing so on behalf of the beneficiaries. So they're a fiduciary on behalf of the beneficiaries. So the beneficiaries named in the trust are the real owners, if you will. But the trust is always going to have provisions in there. So the original beneficiaries are you know, Sam and Sue, and
Yeah.
upon Sam's death, Sam's share is going to pass to Sue or pass to whoever. So the terms of the trust will answer the question for us. If one of those beneficiaries dies, who's entitled to ownership of the property at that point? So in all those situations there, someone dying does not create any probate issues. There's no question as to who's entitled to own the property at that point. So just the deed, the ownership answers that question. When we've got property that is owned just by an individual that has passed away, or if we had a husband and wife passed by the entirety upon the second of them to die, now we have a question: who's entitled? Who are the next owners of this property? So that's when we have to go through the probate process.
I think that to kind of not simplify it, but just the only time you really need a power of attorney is when someone is alive.
Yep. So powers of
And you're
attorney
gonna,
while you're alive.
yep.
Yep.
So while you're alive, you have a power of attorney, someone who can act on your behalf with your best interest in mind.
Yep.
But when someone has passed away, then there's a good chance that you'll have to file probate depending on how the estate is structured. And
Correct.
it's really important, like you said, to do some estate planning. And there are a great number of estate attorneys in the area that do a wonderful job. But you can keep it simple or you can get pretty detailed depending on the estate. So
Absolutely. Yep.
definitely good points.
So to reiterate, so the power of attorney is only effective while the person is alive, maybe incompetent, but still alive.
Yep.
Once they've passed away, the power of attorney is of absolutely no legal significance. It's not operative anymore. So then you'd have to determine whether or not they have to go through probate, and if so, then contact an estate attorney to file that paperwork.
And the power of attorney, the person who is the power of attorney, they're able to sign all the closing documents as, like the deed and everything,
Yep.
right up to closing to be recorded as long as the power of attorney is recorded.
Correct.
Awesome. Okay, here's a big one. All right. We've got a daughter and her mom is elderly and has a little bit of dementia or Alzheimer's coming on. She does have power of attorney, and her mom, in this case, is going to be going into an assisted living facility. She doesn't need to have probate at this point, but
Correct.
they should make a list of like assets and stuff. So what happens if the mother was in a nursing home? Do you know what happens in that case? Because like they have the house to sell, so obviously there's some value there. And instead of going into an assisted living facility where they'd be paying for themselves, the parent goes into a nursing home, and from the nursing home, how is that going to happen? Like you got mass health and all
Yep.
these. I don't understand a lot about it, so.
I mean, so we're still going to have a situation where mom is alive, although not well, and she's in nursing home. So the daughter is able to sell the property pursuant to the power of attorney, but mom being in the nursing home, if the state through mass health has been here, paying her bills for her, they are likely going to file a notice at the registry of deeds. Registry of deeds is where all the land records are kept. They would file a notice saying, hey, we've been advancing money on behalf of this woman, and we're placing a lien against her house, so that when the sale goes through, we would have to contact Mass Health, get a balance that's due to them, and that would get paid from the proceeds. But that's not really any different than if mom had a mortgage on the property. We'd be calling to get a payoff on that. So it's just, there's money due to a third party through the sale. We don't need mass health approval to sell the property in most instances. It's just a matter of getting a payoff. The only time we would need to get them to approve something is if the balance that was due to Mass Health was more than the money that's coming from the sale. So basically, if the property is underwater, if you will, we're selling a property for $200,000 and Mass Health wants $250,000, we would have to get their consent to sell the property at $200,000 so that they would release their lien on the property.
Interesting. Yeah. How long does it normally take to actually process a probate court? And
So
Massachusetts.
lawyers are famous for having waffling on answers, and every answer always is, well, it depends. So there's a number of variables that go into answering that question. So I'll try to answer that somewhat succinctly. Interrupt me here if I'm not clear on something. So when we've got property, someone's dead, we've determined that we have to go through probate in order to pass title on. The first question is going to be, did the deceased person have a will or not? So the terminology is, if they died with a will, they're said to have died testate, testate, testate. If they died without a will, they died intestate. Both scenarios are going to involve probate, just slightly different, versions of probate. So in general terms, the probate process is determining who has authority to act on behalf of the estate, called the personal representative, and who's going to inherit the property. And ultimately, who has the authority in our transaction? We want to sell the real estate. Who has the legal authority to step up and sign the documents for us so that we can sell? The first step in either probate, whether it's a testate with a will or intestate without a will, is to get someone appointed, the personal representative appointed, someone who's going to be speaking on behalf of, working on behalf of, representing the estate. They basically become the owner of the asset on behalf of the estate. That can take anywhere from a week or two to several months, depending on whether all of the family members are on board and are going to consent to the person that's stepping up and saying, I'm willing to be the personal representative. If all of the family members consent to that, but the form's called an assent, then it can go fairly quickly to get them appointed as the personal representative. Once they're the personal representative, the next question is, do they have authority to sell the real estate? So once someone is appointed as the personal representative, they now have control over all the assets of the estate. They can deal with all of the assets of the estate, except not necessarily real estate. So real estate is obviously the biggest asset in most estates. In every area of the law, real estate just has a special place because it's so important to someone's net worth and whatnot. So once the personal representative is appointed, the question is, well, let me back up. So they don't just, the personal representative does not just inherently have the right to sell real estate. If there's a will, and if in the will, the deceased person specifically stated in the will, I give my personal representative authority to sell my real estate, then the courts will recognize that. They'll say, okay, so the dead person, the deceased person, trusted this person enough that they gave them the authority to sell real estate, so we're going to recognize that. If the will doesn't have that language, or if there's no will at all, so testate with a power of sale clause, we're good. Testate without a power of sale clause, we have issues. Intestate, we have the same issue. We need to get a license to sell from the court. So the license to sell is the second step, where the personal representative says, okay, now that I'm authorized as the representative of the estate, I am now asking the court for permission to sell this house to this buyer for this price. And the whole point of that is to give interested parties, family members, an opportunity to step up and say, no, they're not getting a fair price for this house.
So that's
Yes.
that's pretty interesting. Obviously your home, your real estate is your biggest asset, but what other items have you seen been included in a probate, like cars,
Every asset, every asset.
stocks, bonds,
Yep,
everything?
exactly so.
Checking, savings accounts, they all
Yep.
have to be accounted for with the probate.
Yeah. So we do a fair number of simple estate plans here, simple wills and whatnot. So when we're reviewing with clients their assets, part of the conversation is make sure that everything you own, checking accounts, etc., are owned jointly, so that if one of you dies, the survivor of you just automatically owns that. You don't. There's the tenants by the entirety concept, if you will, except that only applies to real estate. If there's a checking account with both names, just automatically the survivor of the two people has access to those assets. So if someone dies owning assets, financial assets, cars, just whatever, anything that's titled and it's just in their name, you have to go through probate for that.
The other thing that's good to think about too is, like in my case, like I have multiple checking accounts and it's just like you. So I have a beneficiary set up
Yep.
on every one of mine because, just in case, even though I have a will and a complete estate plan.
Yep. Yep,
But
exactly.
it's nice to have that, even like life insurance and stuff, to have a beneficiary so that when your time comes, you've set
Yep.
everything up and that your family is going to be taken care of, because we all want to leave a legacy behind,
No, you're right. So, I mean, oftentimes many assets, checking accounts with a beneficiary clause, et cetera, life insurance proceeds, 401k, et cetera, all have beneficiary clauses with them. So those are all assets that are going to be dispersed pursuant to the beneficiary clause. You never even get to the will. You never even get to the probate process relative to those assets.
Makes it a little easier.
Yep.
Yeah. Yeah. What kind of responsibility does the person who's appointed as the executor of the estate or the
Yeah.
probate,
So
what kind of responsibilities do they have?
So they're a fiduciary. So meaning that they are empowered. They have power. They have authority. They're in control of all the assets, but they're doing everything for the benefit of the heirs of the estate. They've got to answer to the heirs of the estate. So they've got to preserve the assets, protect the assets, maintain the assets to the extent that they're selling the assets, sell them for the best price they can get.
Yeah.
And because of that, so when you've got an estate where the personal representative is going to be, our seller, they're going to be the ones signing all the documents. Either there's a power of sale in the will, or they've gotten a license to sell. The offer that you're all putting together, the purchase and sales agreement, is always going to need a clause in there that the personal representative's authority to sell this property is contingent on the probate court giving them that approval. Because in theory, under the law, they are tasked with getting the highest price. So in theory, if another offer comes in that at a higher price than the P&S you already put together, they are obligated to terminate buyer number one and move on to buyer number two at the higher price. And I say in theory only because I've never ever seen that happen. Because the practicality of it is, once a property is in MLS, is under agreement, buyer agents just stop showing the property.
Yes, they do.
Okay. But again, if a buyer came in at a higher price, the personal representative would be obligated to take that.
That's pretty interesting.
And just one quick comment on the terminology personal representative. So that's a relatively new term that's used. If you go back some years ago, you always referred to this person as the executor of the estate. So a lot of people are more familiar with that terminology. So we're talking the same thing, except an executor was only if there was a will, and if there's no will, they were called the administrator of the estate. So administrator without a will, executor with a will. The terminology is now personal representative in both cases.
So the next question is, can the personal representative be reimbursed for their time and any
Absolutely.
expenses? And how is that work? Do they just keep a journal, or how does that work?
Yep, exactly. So I mean, certainly any money that they expend, they're entitled to reimbursement for those funds, and they're entitled to compensation for their time. And there's no hard and fast rule as to what that compensation is. They would just petition the court and saying, "Hey, I've spent 100 hours. I bill at $20 an hour or $100 an hour, or whatever the case may be." And just depending on the circumstances, for the court would approve that, or family members would approve or disapprove of it.
Oh, that's interesting, but I mean, if it's through family members, that might not happen.
Well, I was gonna say, so
you know how that happens sometimes.
So usually the personal representative is going to be a family member. Usually they just feel it's part of their responsibility as a son or daughter or whatever to do this. But where it's there's one son or daughter out of five siblings that's doing all this, and and the others are not helping out at all. They're entitled to compensation. You just don't usually see it.
Yeah, I've actually had attorneys who are personal representatives that we've listed properties for because they're representing the estate as an outside an outside party. So,
You know, we have clients not infrequently when we're putting together an estate plan. They're saying, "Can you be my personal representative?" And I saying, "I don't think you really want me to because that is going to be expensive."
yeah,
Yeah, I mean, there's a lot of just legwork, and that's that's expensive. So it's much better to have a family member who's willing to step up and serve that role.
yeah. Have you noticed any major difference between when you are selling a real estate, somebody's real estate between it being a traditional sale where there's no probate or personal representative versus someone who is a personal representative? Is there any more involved that you've noticed in a transaction?
I'm sorry. Ask that
So
again. I'm sorry.
you have a sale, one's a traditional, it's just regular home buyer and seller, and then another one we have someone who's nominated as a personal representative who's handling transactions.
Yeah.
There's no real difference between no additional paperwork or anything special that
So
needs to
then,
be
on the buyer's
done.
perspective, from a buyer's perspective, no, there's just the possibility of some time lag because of the probate process. And I never really answered your question about how long probate takes.
Like you said, it could vary,
Yeah,
but
but if there's a will, and if there's a power of sale clause in that will, we're talking about maybe 2 weeks start to finish.
oh,
Uh,
that's good.
if there's no will or a will without a power of sale, that can easily take a month or two. Um, so,
We usually kind of figure here 6 weeks
yep.
to be on the safe
But,
side. Sometimes,
but if you've got a will and you've got the power of sale clause in there,
it can
very,
go much
very
quicker.
simple. I mean, we've had a couple of situations. One, sadly, just a month or two ago, where during the transaction, so we've got a signed purchase and sales agreement by an elderly seller, and they passed away during the transaction.
Hmm.
We still hit our closing date because they did have a will. There was a power of sale clause. We were able to just get that into probate court, and like literally a week and a half later, we had all the probate approvals that we needed because they had that power of sale clause in the will.
Yeah, and that's why I brought up power of attorney in the beginning, because a lot of folks will think, oh, well, I have a power of attorney. That's fine. I can still, because I've had
Yep.
sales. Unfortunately, the seller has passed away right before the
Yep.
closing. And
Yep.
yeah,
Yeah. So
this
yeah,
just
yes,
makes it
sadly,
difficult.
as we've discussed, power of attorney is no good anymore.
Yeah, no, makes it difficult. Um, Trying to think of other thoughts because I've gone through so many different things about probate, have you no real delays or anything because of it, just like you said, if
So,
somebody passes
where there can be
away,
significant delays is if the family members don't get along with each other. If you've got multiple siblings, and mom loved you more than they loved me, kind of, that kind of thing. And they think that whoever the personal representative is isn't doing their job, isn't getting top dollar. So there can be some infighting in those situations, and that can slow the process down.
a lot of large families, I've seen this happen, can be difficult, for many
Yep,
people,
yep, exactly.
and there's nothing like that when you lose a parent or a sibling, and you need to make sure that everything's taken care of. I mean, I lost both my parents and my brother and needed to make sure that everything was taken care of for my niece and everybody, so it's a
Right.
lot involved, and I don't think people realize how important it is to have these documents ahead of time. And how does the involvement of a beneficiary or heir affect the sales process of a real estate? So if someone's a beneficiary, so that the home technically could be transferred to them,
Yep.
how does that affect it?
So, yep. So when we've got a will, in the will, it's going to designate who the assets are being distributed to. Who the terminology is devotee, but who's going to inherit the property from the estate. If there's no will, then it just automatic. State law makes some assumptions as to who the deceased would want to leave their assets to. They're going to, it's going to go to spouse, children. If there's no spouse, no children, it's going to go to parents. If there's no parents, it's going to go to siblings, and you just keep looking, and until you find a live body, the closest next to kin, and they're going to inherit the property. But in the typical situation where the property is being sold shortly after death, the heirs of the estate, the devotees of the estate, are not themselves able to convey clear title to a buyer because there's a 1 year period after death for creditors to step up. So, unnamed, unknown creditors have a lien against the property for up to 1 year after the date of death. So the estate can't transfer clear title to a buyer during that first year because of potential liens. A personal representative can because the personal representative is tasked with, once the property is sold, taking the money from the sale, keeping it in the name of the estate, not distributing the money out to the heirs in case those creditors come up. So that's why you'll sometimes hear people say, well, probate takes so long, it takes a year or more before you can close out the probate. That is true as far as all of the heirs getting their disbursements, but that doesn't play in at all to the sale itself, because the personal representative can sell with a license to sell, with a power of sale in the will. They just can't then distribute that money to the family and whatnot. But the family members can't themselves convey property because they're not held to the standards of the personal representative. The personal representative, in part, is answering to the court to make sure that they're protecting the assets not only for the family members but for potential creditors and whatnot. So they can't distribute during that year, but they can sell the asset.
So one last question. So this is going to go on a little bit different. So you ready?
Yep.
When you have a property and you inherit it, or when you own a property and your parent is older and they're like, you know what, I want to put it in your name. Does it make sense to do a deed to your son, daughter, niece, nephew, whoever, and put the deed in their name? Or does it make more sense to set it up as a trust or name them as the sole beneficiary so that when they do sell the property for tax purposes, what would be your suggestion?
Oh goodness, we just opened up a half-hour conversation
I know
here.
we did, but I'm gonna make it short and sweet because I know how I feel about it.
Yeah.
And
Okay. So we frequently have elderly clients that are just that. I'm getting old. I want to simplify my affairs. I want to deed the house to my kids. So we say we're not going to let you do that because as much as you love your kids and as much as you know your kids love you, things happen. Once you've deeded the house to the kids, and with the elderly parents intending to still live in the property, they've lost control of that house. If their kids ever run into financial difficulties, the kids' creditors are going to take that house. So even if the kids don't turn on their parents, which we've seen. Sorry, mom and dad, I've got tough times. I need the money.
I need the money.
I'm kicking you out of the house. I'll pay for that later in life maybe, but right now I need the money. So that's just too risky. There's too many things that can go wrong in that situation. So a compromise. There's several ways to accomplish this. As far as simplifying things, getting things to the kids upon their passing. One is to deed it to the kids, but retain a life estate in the property. So the life estate basically says that mom and dad still are in sole control of that property during their lifetimes, and upon their passing, their life estates just automatically terminate, and now it's the kids' property. The downside to that is if mom and dad want to sell the property, they say, hey, I've lived a good life, I've worked hard, I want to play now. Let's sell the house, take all the money, and cruise the world or whatever. Well, they've just ceded veto authority to the kids because the kids are now partial owners of the property. So any sale of the property is going to involve the kids, and they can stop that. You can put it into a trust, as you suggested. That's probably a better way to go. So in the trust, the terms of the trust are going to just stipulate, who gets to reside in the property and such. Creditors aren't going to be able to get at the kids' interests and things of that sort. But that does avoid probate and simplifies getting things into the kids' names, after they've passed without having to go through probate. But as I always say, anything you're doing here is of zero benefit to you, mom and dad, other than whatever peace of mind it gives you that you simplify things for your kids. You are complicating your life in order to make things simpler for your kids. Whether you're doing a life estate, whether you're doing putting title into a trust or whatever, you're spending money to do all that now. You're losing some control over the property if you do that. And the only one that benefits is the kids, and that you've simplified things for them when they passed away. So I'm a real estate attorney that dabbles in estate planning and trust. If you go to an estate attorney, they'll say, well, of course, you should have this complicated trust, and you should put everything into the trust to avoid probate and such. To truly avoid probate, every single asset has to go into that trust. Your house, your checking account, your investment accounts, and whatnot. So there's just a lot of aggravation involved in that. But again, an estate planning attorney will have a different take on this than I do, and may have a better sales pitch as to why it's advantageous. But I'm not a big fan of doing that.
Yeah, well, I'm not either. And I always explain to my clients that, yes, if you deed it over to your children today for $1, and it might be worth 400,000 today, and 3 years from now, when they're ready to sell it, it might be worth 600,000. So now they're going to be looking at capital gains.
Exactly. So I didn't even touch on the tax component.
Difference.
Yeah, exactly.
But that'll be another webinar for another day.
Yeah.
But I'm just saying, so there's a lot to think about, and I really appreciate you taking the time to spend this with me and share the information. And everybody out there, please get a power of attorney, set up your estate planning, even if it's basic, and have a will to protect your assets in the long run. Thank you so much, Craig. I love working with you and your team, and we'll see you again.
Thanks, Joanne.
Thanks, Craig.
Bye-bye.
Bye-bye.
Bye-bye.